Okay, we are on the record in file 21-20513-FH, People versus Robert Joseph Mattson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Mattson is present from the Lenawee County Jail. Mr. Mattson, my court notes indicated that at the last hearing, you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney. And if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to
All right, everyone, buckle up, because we're stepping straight into a courtroom showdown with Judge Oles, where Mr. Robert Mattson, a self-proclaimed sovereign citizen, is trying to bend the law to his will. He's already waiving his right to an attorney, claiming some kind of fighting clause. Yes, you heard that right. And thinks he can reopen his probation case just by arguing in circles. Today, we're going to watch the court navigate these wild claims, explain why probation isn't a suggestion, and see what happens when someone mixes fantasy with legal reality. Trust me, this is going to get intense, so stick around. You do not want to miss how this unfolds.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Mattson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with
have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me. That's fine then.
All right.
Now here's a key moment. Mr. Mattson wants the court-appointed attorney to handle paperwork, like some kind of personal assistant. But that's not how it works. The law is crystal clear. Public defenders exist to represent you, not run errands or act as your administrative staff. The judge has to set him straight, and it's fascinating to see the clash between the courtroom structure and Mr. Mattson's unconventional legal strategies. Would you have thought someone could seriously expect a lawyer to just handle paperwork while they play solo in court? This is a textbook example of why understanding legal procedure matters.
So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all.
Citizen.
Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within 90 days to a trial or sooner.
All right. So Sierra will need about a 1 hour hearing on a probation violation.
as well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day.
Barv, boom. Here's where it escalates. Mattson demands a 1-hour hearing with all the arresting officers and even wants a sergeant in uniform. He's essentially trying to turn a probation violation, a procedural matter, into a full-on spectacle. The judge shuts it down, explaining that the attorney's job isn't to manage these theatrics. Audience, what do you think? Was he trying to make a legitimate point about his arrest? Or is this just courtroom grandstanding? Drop your thoughts below, because this is where legal reality and sovereign citizen theory collide head-on.
April 8th, I'm sorry. Monday, April 8th at 3:30. Mr. Mattson, do you want to be present in person for that hearing, or do you want to do it by Zoom?
It doesn't matter. Judge, whichever is best for the courts, be fine with me.
All right, I think it will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day?
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names. But any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination, how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of. I don't see where any of it's going to affect the courts in any way, shape, or form.
All right. So the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
It's not about the arrest. It's about the arrest for the violation of probation as well.
All right. The only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ, because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you.
All right, pay attention here, because this is crucial. Probation violations do not come with a right to a jury trial. Many viewers might assume criminal case equals jury trial, but probation is a privilege, not a right. The judge patiently explains that the only question is whether Mattson failed to report. Nothing about the circumstances of his arrest. This moment perfectly illustrates the gap between perception and law. Remember, probation is designed to keep someone in the community under supervision, and skipping check-ins isn't just a small slip. It triggers serious legal consequences.
You're Michael Olsaver, aren't you? There was
Yes, I
Judge
am.
Ancelone, and then there was you. I've seen both.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on
Well, hold up
Monday.
then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because
You
I
are
was
alleged
at
to
risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance. And you were placed on probation as a result of that. Your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation. So the court will conduct.
Let me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Matson. This hearing is concluded.
And there you have it. This hearing wraps up with Mr. Matson's arguments firmly overruled, and the court setting the next session for April 8th. The takeaway: sovereign citizen arguments may sound bold, but the law doesn't bend for creative interpretations. Probation violations are procedural, not theatrical, and the judge's role is to enforce the rules fairly, regardless of wild claims. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss the next twist when our signature mullet returns.